Good morning, everyone, and a warm welcome to Clover's HR Employment Law Update for March 2022. Really lovely to have everyone joining us this morning, and really looking forward to taking you through some of the key and the main employment law changes that are either about to happen or are in the process of occurring, and of which you should be aware of in terms of the employment law and people issues in relation to your organisation. So lovely to have everyone along and look forward to taking you through some of these changes. As some of you are probably aware, it's our 5th birthday. So we are really, really pleased that we have now been operating for 5 years and providing commercially astute and in-depth quality HR and employment advice to businesses across a broad spectrum, and to thank all of you for your support during that journey. So let's jump into this. I'm going to take you through the key changes by way of update, and I'll leave deliberately some time at the end for any questions that you may have. You can put stuff in the chat box if you want to, if you want to make a comment or an observation. But if there's something particular that you want to ask at the end, then please feel free. Okay, so one of the big changes that is afoot at the moment is something that you may or may not heard of, which is the Employment Bill. And it's a new piece of legislation that is working its way through Parliament at the moment. So it goes for a second reading tomorrow, and then eventually it will go through the Houses of Parliament and go to the House of Lords, and eventually get royal assent and become enshrined in UK employment law. And that process is going to track throughout 2022. So if all things go well with a fair wind, by the end of the year, it should become law, and it should be on our statute books, and we'll keep you updated in relation to the bill's progress. Originally, it stalled due to COVID, but we need to be aware of the employment bill because there are a number of changes that bill will introduce that affect businesses operationally and also from an employment law perspective. And I've highlighted some of those key changes on the slide that are part of the employment bill. So one of the really important changes is the idea of making flexible working and the right to request flexible working a default position in terms of employment. So flexible working, once the bill goes through, would become the default position. And the other thing that it does is it establishes a single body, a single government agency, which is responsible for enforcing the basic rights for vulnerable workers. And it also has legislation included in it whereby those of you who are in the hospitality sector, for example, restaurants, hotels, there becomes a duty to pass on any tips, any gratuities given to waitresses or waiters or individuals working within hospitality to their workers. It also extends in some scenarios redundancy protection rights. And I've put those on the screen for you. So for example, issues in relation to being offered suitable alternative employment, rights for pregnant employees, and also in relation to shared parental leave. So you can see that some of the changes under the employment bill are quite far-reaching and quite profound. And the idea behind the bill was to enshrine and protect certain classifications of workers, and also to bring into legislation a new definition of what a worker she or he is. And you'll see that there are new rights for carers, for example, to take 1 week of unpaid statutory leave. And quite a controversial, some of you may think, others may disagree, but it's the idea that for those who are on 0 hours contracts or variable flexible employment contracts where work isn't guaranteed, to give a right to workers to request from their employer a more predictable and stable contractual arrangement after successful completion of 26 weeks continuous service. And that's another perhaps quite far-reaching change, particularly for those of you who are engaging people on 0 hours or flexible contracts. Now, as I said at the start, it's not law yet, it's going through the Houses of Parliament, but you can see that some of the changes are quite profound, and you will need to think about changing employment contracts, employment handbooks, for example, when that does hit the statute books and becomes law. Another really interesting thing that flows from the employment bill relates to sexual harassment and the duty of care that organisations have in relation to sexual harassment in the workplace. And the key defence at the moment is that an employer can argue, the organisation can argue, that they took all reasonable steps to prevent harassment from occurring in the workplace. We think that once this employment bill becomes statute and becomes law, there will be a new duty to prevent sexual harassment within the workplace. And we think that employers are going to need to be able to demonstrate and show more robust anti-harassment policies and procedures in the workplace, and also demonstrate up-to-date training for employees in relation to sexual harassment and preventing it within the workplace. You know, something that is going to occur at some point within the year, and something that has, or potentially will have, once it gets onto the statute books, quite profound consequences. And we can update you, and we will update you in relation to the employment bill and how it develops and how it unfurls, but just to kind of make you aware of some of those changes, which are quite far-reaching. Okay, turning to more budgetary and financial aspects of changes to employment law, there are going to be various statutory changes to things like statutory sick pay and the minimum wage, which I'd like to take you through so that you are updated and aware. So statutory sick pay is going to increase, and it will increase to £99.35 per week as part of the new budget from April 2022. There will also be an increase to statutory maternity, paternity, adoption and shared parental leave, and they will increase to £156.66 per week. And as we know, the government are introducing quite a significant increase in employee national and employer national insurance contributions, and the NIC rate is going to increase to 1.25%. And if you've looked at the HMRC tax guidance on their website, they have suggested that on pay slips, organisations and employers do something to kind of explain the reason why national insurance is going to go up to 1.25%. And they've suggested that pay slips have words to the effect of there's been a 1.25% uplift in national insurance to fund the National Health Service, health and social care. And the intention is that perhaps that will be put on pay slips, digital pay slips, and also hard copy printable versions if you're using them in your organisation, to explain that to employees. And also so that you avoid people with loads and loads of payroll queries in April saying, why has my salary changed? Why have my deductions gone up in terms of NIC? And these are all in place from the 5th of April 2023 in relation to those changes. There are also changes to the national minimum wage, and these will apply from the 1st of April. And I've highlighted them for you on the slide. So the national minimum wage will increase to £9.18 per hour for those in the age bracket of 21 to 22 years of age. For those between 18 and 20, the national minimum wage will increase to £6.83. And for 16 to 17-year-olds or those on apprentice schemes, it will go up to £4.81. And for many of you who are perhaps employing people who are predominantly 23 years of age or over, the national minimum wage will increase to £9.50. So really important that you don't forget the increase in relation to those national minimum wage increases, and the payroll and salaries are adjusted accordingly to reflect those increases and those changes. We will also see more generous and increased tribunal and compensation rates as from April 2022. Now, there are going to be increases to the calculation of the maximum that an employee, she or he, can claim in relation to the maximum or upper limit for 1 week's pay. So it's currently £538 a week, and it will increase to £544 a week. And in addition, the maximum compensatory award for unfair dismissal, should somebody be successful bringing a claim for unfair dismissal at the Employment Tribunal, will increase from £88,519 to £89,493. And the minimum basic award for specific types of unfair dismissal, and that includes health and safety dismissals, will increase from £6,562 to £6,634. And those figures reinforce, if we needed to think in those terms, the importance of having really robust employment law, HR policies, handbooks, discipline and grievance procedures, good line management training in relation to handling discipline and grievance, and all the kind of proactive measures that your organisations can take and that we can support you with in relation to minimising and mitigating risk from employment tribunal litigation, because obviously the maximum compensatory award is a significant sum, and anything that organisations can do to reduce any exposure to employment tribunal litigation is something that you should seriously consider. Now, thinking ahead in terms of holidays as we get into spring and British summertime begins, I think in 2 weeks' time, there are a couple of public holidays to be aware of, and thinking in terms of labour force planning and employment planning and holiday scheduling within teams and departments. There will be an extra public holiday on Friday, the 3rd of June, to mark Her Majesty the Queen's Platinum Jubilee. And there's a knock-on effect because the late May bank holiday has moved from the 2nd of June, which makes that effectively a 4-day weekend. So operationally, thinking around forward planning and notifying individuals in relation to holiday entitlement, and also thinking operationally about who's going to be in the office or who's going to be in the organisation. Worthwhile noting that Friday the 3rd of June marks the Queen's Platinum Jubilee, and then we've got that late May bank holiday to consider, which effectively makes it a 4-day weekend. Now, a couple of interesting case law updates to draw your attention to. Holiday pay calculations and calculating holiday pay accurately has always, or can always be, something of a headache and something sometimes that is difficult to get right. And we expect 2 judgments around holiday pay to be decided at some point in 2022. And again, we'll, just as we discussed in relation to the employment bill, that's something that we can advise you on and give you employment law updates in relation to once those cases are decided. Now, there's one case called Harper and Brazell, and this concerns holiday pay and holiday pay calculation for a casual worker who was contracted to work all year, but only worked term time only. And the judgment, when it's delivered, could potentially clarify lots of the issues around holiday pay, and in particular, the practice of paying a supplement of 12.07% for casual workers, which some of you may apply when calculating holiday pay for people who work on a casual or ZTC basis. And then there's the ongoing Pimlico Plumbers litigation, Smith and Pimlico Plumbers, and that concerns the extent of holiday back pay in circumstances where the organisation treats the individual as being self-employed and having self-employed status, but actually it transpires that they are actually a worker and therefore they are entitled to be paid full holiday pay. One of the things that the employment bill is going to do when it's introduced is clarify the legal definition of what a worker is and tighten up some of the loopholes around bogus self-employment and precarious employment when it hits the statute book. So that's something to be aware of. So it will be interesting to see how Harper and Brazel and Smith and Pimlico Plumbers play out and whether or not calculations in relation to holiday pay are finally resolved one way or the other. Another thing that we are all familiar with is the way that we've had to pivot and adjust to undertaking right to work checks during the COVID-19 pandemic. And many of you will have become adjusted to doing them digitally and doing them over Zoom or Teams. And effectively the right to conduct right to work checks remotely. That arrangement will remain in place until the 30th of September of 2022. And then that kind of transition will come to an end and organisations will be obligated to return to the usual pre-COVID-19 right to work checks that we are all familiar with. And they entail either carrying out manual right to work checks using original documentation from primary groups A and B, the usual kind of documents that you're all familiar with. So I think that's something to be really aware of, maybe something to put in your calendars. It's not that far away in terms of time and space. So from the 30th of September 2022, we will revert back to the ordinary way of conducting right to work checks, and the current mechanisms of being allowed to do them remotely will end on that date. Just some brief comments in relation to gender pay gap reporting. This is set to be reviewed in 2022. And there may well be changes in relation to gender pay gap reporting obligations. But in the meantime, the deadline for submitting reports is expected to return to normal this year. One of the changes that is kind of afoot at the moment is adding an additional obligation for ethnicity pay reporting alongside gender pay gap reporting. And again, if there are developments in relation to gender pay gap reporting changes, and including some element of ethnicity pay reporting, then obviously that's something that we will update you with and make you aware of by way of employment law update. Okay, I've gone through that relatively swiftly because I wanted to cover everything and just take you through the main changes in relation to employment law over the coming months, particularly things like the national minimum wage, for example, compensatory awards in the tribunal, and give you an overview of the employment bill. So I will kind of let you ask any questions if you want to in relation to any of the topics that we've discussed, or if they particularly affect your organisation in any particular way. Okay, well, I don't think we've got any questions, which is fine. But if you do have any questions, or if there's anything that you want to ask, please feel free to reach out and let us know. We'll be more than happy to advise you if you do have any questions or queries. Otherwise, thank you very much indeed for attending our employment law update. And I hope that you have found that constructive and useful.